I don't. I've never.
All righty. Welcome everybody to this week's or bi-week's edition of Expert Witness with Doug Miner and Stephen Palmieri. If you are joining us live, put in your comments below. Obviously, we are here to kind of give you guys open mic session with a true bona fide credit reporting damages expert witness. Doug Miner, how are you doing today, sir?
I'm doing excellent. Excellent day today. Excited to go into the show today. This will be fun.
It is. It is. So for those who do not know you, Doug started off in credit repair, and then one day an attorney hired you to give an opinion on something, and they paid you handsomely for that. And you were like, "What just happened?" And your friend was like, "I think he paid you like you were an expert witness." And you were like, "What's that?" Then you figure it out, and here you are now full time. You have done lots and lots and lots and lots of cases, and this is your full time profession. And so you're kind of like the guy who goes in, you're even more valuable than the attorney because you're the one who gives the attorney what he needs, right? The ammunition that he needs to fill in all the little holes. Like the attorney is kind of like like you fill in all the holes of the Swiss cheese. He's like, I got this Swiss cheese and I need some cement in the middle, and that's where he comes in and pays you and you give him some opinions. So let's talk about what goes on in your world, man. Let's educate our people out here
Yeah.
on the expert witness world, man. What's been happening, brother?
Yeah. So we're gonna educate them a little bit today on rebuttal reports. I think in the other shows in past we've talked about an expert report. You draft one when you're hired and you're retained by counsel. You have all the documents that you look at, but we need to talk about a little bit when a rebuttal report comes into play and what it really means. And so when you are on the plaintiff side or the defendant side, typically you have, let's say, Bob Smith, quote unquote, against big corporation or data furnisher, whoever it is, right? Well, the plaintiff expert writes their report, hands it off to the attorney, which then passes it through to the opposing counsel. Then their expert's going to issue a rebuttal report, basically having maybe some similar opinions, maybe have opinions that are, let's say, completely disagreeable to yours, or in some way they're trying to discredit your opinion or support their own opinion about something that's different than yours. But that's typically the way it goes. And so you and what we talked about before the show started was I'm actually in a situation where I'm doing a rebuttal report to a rebuttal report because I did the initial report, it was rebutted, and now I get to rebut the rebuttal.
That
So
makes you a real rebut head. But and also, Siri, let's back up for a second here for those of you guys who are watching. Okay, so a couple interesting things that Doug that you had mentioned. So you get paid to give opinions that are admissible in the court of law. Now, last
whoa,
I
whoa,
checked,
you would stop on that for a second. I'm paid for my time. I'm not paid
okay,
for.
that's not what I meant to say. Okay,
Yeah.
yes, you're paid for your time, but what you do with your time, yeah, what you do with your time is you provide opinions. That's kind of the takeaway that are admissible in the court of law. Now, typically speaking, the average Joe Schmo cannot give an opinion to the court, right? It's really that privilege is kind of like is left to expert witnesses. Do you want to kind of expand on that a little bit for our listeners?
Well, I think what you're getting at is to be a qualified expert and to give your opinions or have the court accept your opinions in a case, you have to be qualified to do so. As opposed to, I think what you're saying, a lay person to give their opinion in court may not hold much weight, if any at all, depending upon if the court, first of all, if the court allows it, second of all, if it has any relevance to the case, or third, if even if somebody does say something, will the judge allow that to be heard, let's say, by a jury or not? So there's a couple of different things going on there.
Yeah, so let's just kind of expand on that, right? So I mean, the whole value that you as an expert witness or a qualified expert bring to the court case, you're an expert and you're a qualified expert because of your knowledge, skills, life's experiences, all of that kind of stuff. So the average person, like, I mean, if you've just got, so like, in other words, if you got somebody who's maybe a witness, um, to a crime or something, they pull them up on the stand. Really, that person's testimony is supposed to be limited to like statements of fact. I saw this person pickpocket this person or whatever. Well, do you think that? I mean, do you think that whatever? Well, no, you can't talk about what you think. You just have to give us the facts of what you know. But now, because that person is not being called up in the capacity of somebody with knowledge, skills, and experience, they're being called up to really just talk about what they saw. Whereas in your case, you've got the knowledge, skills, and experience, and that's what makes you an expert. So you're one of the few types of people who actually can go in and provide opinions. And so that's valuable to the attorneys because they've got a set of facts and they've got some laws that they have to jam the facts inside of. And then where you kind of come in is you're able to look at the facts, and you don't even look at the laws so much, right? But you look at the facts and you give an opinion on how the facts support, I guess, whatever the causes of action are. I mean, you can't make legal opinions, but it's like, hey, were there damages? Well, you're obviously a credit damages expert. So, and why are you an expert? Because you were in the mortgage industry for like a gajillion years, and then you've looked at tens of thousands of credit reports. So, you can give an opinion on how their malfeasance damaged somebody with credit. And that's a very unique position to be in, which to your point earlier, you should get paid for that, right? But I want to just kind of make a point that a lot of people may not realize that, but the average person just can't really go up on the stand and like give an opinion because it'll get struck down, Whereas you, once you're qualified, let's talk about what is your opinion on, like, it doesn't hold the weight of law per se, but like, how do they assess your opinion? Is it now just a matter of, if you're an expert with one opinion and there's an expert on the other side with another opinion, how does that relate to a legal conclusion that ultimately is decided?
Yeah. Okay. That's a really loaded question. There's a lot of pieces to that, right? As far as giving an opinion, I may look at documents and credit reports and claims made by the plaintiff in a case. I may even have the opportunity to speak directly to the plaintiff as to, what they were doing at the time, what were they thinking about when they applied for the credit card or the mortgage or whatever was going on in their life, and the implications or the actual events that happened around them. Because let's just assume something is inaccurate and it's been put on their credit report, which has eliminated their ability to refinance the house that they were living in, or to purchase a house that they wanted to buy that otherwise they would have been able to make the payments and qualify for. But for this information being on their credit report, they're not able to do so. So that's sort of the unique position that I'm put in quite often to calculate the damages. You really have to understand the individual and their socioeconomics of the individual and their pattern of usage, right? Just because one person's credit report was affected, and we all know this, right? When we look at credit reports, let's say it's a 60-day late, and that 60-day late on somebody with a previous 800 credit score as opposed to somebody with a 630 credit score, that 60-day late is, from a point value, is going to differ in the impact on the person. And also it's going to differ in the underwriting guidelines of that person. But where I sort of take it in the damages calculations, you have to also look at the underwriting guidelines that are being applied. And then there's times where I think a lot of the credit people understand debt to income ratios that are calculated in the mortgage industry when you're buying a house, or even maybe if you're looking to rent a house, how are they going to underwrite you? Or if you're going to go buy a car, the underwriting standards may be a little easier than mortgages, but they're still going to underwrite your qualifications. So, and this is speaking from being on the plaintiff side that we're talking about, right? So I can do that, and I can speak to those issues, and I can speak to the damages and how they're calculated. But the expert on the other side, who's done a rebuttal report, most likely disagrees in some form or fashion as to my opinions about the case. But I think one of the things is, when you do either you get to do a rebuttal report, or if there's one done on a report that you've done, a lot of times you may get an idea of what the opposing counsel's position is, or their opinion about a situation. That, I may say something in the lines of, oh, well, this person's been damaged, $100 to $150,000 due to this stuff on their credit report. The opposing expert may say there's no damages at all because there's no proof of something or other, right? There's no proof that this person tried to apply for a mortgage. And that kind of comes up fairly often, in that if you've been in the mortgage industry as a standard practice, if someone comes to you and says, hey, I want to refinance my house, but before we go through all the paperwork and run my credit and open escrow and order the title report and appraisals and spend all of this money and have all this work done, this is on my credit report. Well, so the loan officer is going to say, well, if that's on your credit report, we're not going to be able to do the loan. So from a credit reporting standpoint and from a proof standpoint, you may not have an inquiry from the mortgage company, but it doesn't mean that this person didn't want to refinance their house. You see what I'm saying?
Sure. And so when you do an expert report, that's evidence, right? Like if it's submitted into the court, that's submitted in as evidence. Is that correct, or is it submitted in as something else?
Yeah, right. It's submitted. I think that's what I think. I want to break it into in the most simplest form. When I do a report, or there's a rebuttal report done, there's a sharing of information. It's not like you can hide things from people. At least that's my opinion. It's sort of like, okay, here's all the documents that I looked at to form my opinions, and there may be a list of 10 to 20 documents that I looked at, right? Which could total, 200 to 500 pages of documents that you've reviewed to develop your opinion. And you're telling the other side, based on these 500 pieces of paper, this is my opinion after reviewing these documents. So it's not like you can just hide things from the other side. So yes, as far as it being an exhibit in documents that are submitted into the court and are used in the courtroom, absolutely.
But I mean, I think I want to drill in on that, because you're talking, and this show is kind of about the rebuttal to the rebuttal. Why does it even get to that point, right? Because that's how important your job is. If it's a really tight case or a contested case, expert witnesses really can mean the difference between one side winning or losing, potentially. And some people pull in expert after expert, maybe not on the average case that you see, but if you think of some of these really big giant cases, not even financial, but like just big giant cases that are out there where you've got a bunch of huge powerhouse companies fighting each other, not Susie Consumer versus the powerhouse, but powerhouse versus powerhouse. I mean, they're going to be lawyered up and they're going to be experted up. And actually, in one of the prior shows, you had said that sometimes the lawyers will retain you just to have you on their side before the other side retains you. And that goes to show how important it is what you do, because the experts, I mean, you're supposed to be ethical and honest and all of that. Not saying you're not, but supposed to in a very broad sense. You're not supposed to lie, but it is your opinion. And so you can give an opinion that can potentially sway the facts, like, because you've got different types of facts in the court case, right? I mean, you may have, like, I don't even know what they're called, but like you've got real facts, which are things people can touch and feel and stuff like that. And then you have opinions, which you can create an opinion because you are an expert and you're a qualified expert. That opinion becomes evidence that could be admitted. Maybe we could talk a little about how that relates to you being a rebuttal of a rebuttal. I mean, because that's obviously an important situation. If you're having to write a rebuttal for their rebuttal on your original thing, you play a hugely important role in these cases, don't you, Doug?
How do I say? I think that my reports and my opinions in cases can have let's say, material impact on the outcome. Sure, right? The situation doing a rebuttal to a rebuttal, I have a case where that's happening. As far as why and how the legal ramifications or why it's actually transpiring that way. I don't know. I'm not an attorney, and I don't know the legal reasoning behind it, right? I just look at it and say, okay, well, I'll read through the other report and see if there's anything that I need to respond to that maybe I disagree with, or maybe give some more clarity on an opinion that I had previously that's being questioned. And I think that's probably the big thing for everyone to understand is it's my opinion about something, but more importantly, I have to be able to support my opinion. Meaning, I have to sort of be able to say to Stephen, hey, Stephen, it's my opinion that they've been damaged because of these reasons.
Sure.
And the
Sure.
documents that support that opinion are this credit report and that application and this underwriting guideline all support my opinion. And this is how I came to my opinion, right? So it's doing rebuttal reports is an important part in giving let's say an objective view or an opposing view or an opposing argument in some way in the proceedings that are going to go on. But I think everyone, a couple things, sir, as far as the takeaways are concerned, is it's like, look, I go into it assuming that there's going to be a competent expert on the other side, and I really focus on my opinions are my opinions. Now, look, Stephen, you and I could work on opposing sides, and we could have opposing opinions just because of our backgrounds and our understanding of certain information. But there are times, even in a rebuttal report, where you're going to agree with the other expert, maybe on part of an issue, or maybe you agree with something that is said, right? I think that's the whole thing. You need to stay grounded in who you are, your opinion, being able to support it, and then when you do the rebuttals, if you're questioned on it, which there's a high probability that you will by the opposing counsel in a deposition or a trial, you're able to support your opinions with the facts or with documents.
So let me ask you. So in this case, kind of what you're talking about is you've been asked to give a rebuttal to a rebuttal. Now, would it be more beneficial to the attorney if this person had access to another qualified expert that could give the rebuttal to the rebuttal? Because it's kind of like you're commenting on their rebuttal to what you originally commented on. I mean, is there any sort of like, as a matter of strength and weaknesses? I mean, maybe you're all they've got, and maybe there's nothing wrong with it. But would it be better if they could have a second expert come in to do the rebuttal to the rebuttal and say, hey, what Doug said the first time was totally cool, and I'm in all support of it, or whatever? Like, does it matter that you're kind of like rebutting their rebut to your original statement, or I mean, is this not even an issue?
I can't really. I guess the best way I can answer it is this: first and foremost, I'm not the attorney, and I can't sort of
Sure.
what an attorney may or may not do on a particular case in reference to my report or a rebuttal report that I've done or a rebuttal report done by another expert, right? I think that's for the attorney to decide what do they want to do. But you bring up the situation where, if there's a report or a rebuttal report and you've had a chance to review it, the attorney may ask me questions about my report, or they may ask me questions about a rebuttal report that I've reviewed. And it's just a matter of, again, getting back to, what's your opinion about it, and how do you support that opinion? What's going on there? What did you look at? What's your experience? What's your work experience? There may be a phone conversation, or there may be an email that you refer to. There could be any number of things that go on. I think the point I really want to make is for people who want to get into the expert work is that make them aware that there are experts that will typically be on the opposing side of you and may have differing opinions than you. And two, you may have the chance to do a rebuttal report on a report that's sent to you. It's not all just, hey, they hire you, you write a report and it's over. It's, hey, you've been retained and now they want you to review an expert report issued by some other credit expert, and they hand it to you and say, okay, hey, what do you think about this? And you may say, well, I agree with that, but I totally disagree with that, or this is partially correct in my opinion, but not fully. It needs to be explained better. There's all sorts of things. So there's this back and forth, and just look at. I sort of view myself as an important piece of the litigation that goes on at times, but there are times where I've had attorneys say to me, "Oh, well, Doug, this is just a small piece of the case," or it may be like, "Hey, this is really important. You know, this is a big part of our."
They're like, Doug, your last prayer, Doug. This is all we've got, man. Make it good, right?
Yeah,
No pressure, right?
yeah, no pressure, no pressure. Just a matter of, I think if you take a mindset that you're trying to teach people and explain things as best you can to a layperson, right?
Yeah.
You know,
I mean, we were kind of joking around a little bit before the show started because we were like, we're going to talk about rebuttals to rebuttals on today's show. And I was kind of like, well, there's really a whole lot in common with credit repair because it's like you write your letter and then they write their response back to you. And then you write round two and then they write their response. Then you go round three and they write their response. I mean, although it's really an entirely different ballgame, it's not really so far off, especially if you're doing pre-litigation disputing where you're actually looking at the facts and doing factual driven disputes to the credit bureaus and to the data furnishers. It's kind of like, kind of like in that case, if you're doing really good factual disputes, those are kind of like your little expert reports as a CRO, right? I mean, because as CROs, we are experts. Now, we may not be a qualified expert in the legal sense, although we potentially could be if we want to go into the legal world, but we're still experts nonetheless, right? We've looked at, everybody has different numbers, but hundreds, thousands of credit reports. If you don't know what you're doing after looking at 1,000 credit reports, you're not giving yourself enough credit because you do, right? So, maybe we can get some analogies there from what you do, and we can kind of adopt those into our credit repair practices, by looking at the credit reports. What are the facts? How can I analyze these facts? How can I put these facts into a document that we can send out? And that's what I share with everybody in the pre-litigation world. It's like, hey, so many people in this industry, they just want to get the deletion, like by any means, whatever the cost. And I get that. At the end of the day, your client wants the deletion, but you can have like no strategy, or you can have a scientific strategy about it, and by looking at the facts and building letters on top of letters on top of letters, because if you can see you ask for this in round one and they didn't give it to you and they didn't fix it, then round two you hit them some more and they don't fix it. That's kind of like the rebuttal to the rebuttal in a weird sort of a credit repair kind of a way, isn't it, Doug?
I think it's a fair analogy, especially for this group of people, right? You're and I like what you're saying. It's like you're looking at the documentation and the facts, and giving your opinion in the letter as to why it should be removed. And here's the reason why. Here's the documents that support my reasoning behind it being removed, or maybe or proving that it's inaccurate. You may have a copy of a canceled check, a copy of the bank statement showing the account, right, that it was charged, or a copy of the credit card bill showing that. I mean, you can have all kinds of supporting documentation to give behind your reasoning why the information should be, modified or deleted or removed from the report in some way. So yeah, that back and forth is similar in the sense that you're looking at their response to what you've given them, and you're acting like you're saying. You're acting accordingly, moving forward with it. So I think that's a great way to communicate it to your group. Is that a rebuttal is similar to that. It's just maybe a little bit more detailed. I'm going to say that's all. That'd be a quick assessment of it.
Well, and in general, we don't get paid nearly as much by the hour as you do for our little rebuttals. Dear Experian, this is my 5th attempt. Why do you keep ignoring me? Lick the envelope and stamp it and mail it out. That's not a $350 letter right there. But again, we joke a lot, but we have a lot of fun on this show. So for everybody who's listening here, again, really the idea is, how can we improve our businesses? How can we think, because if you're thinking pre-litigation, that dovetails perfectly into what you do, Doug. I mean, honestly, because you've got to look at the facts and you have to analyze the facts, and the judges or the attorney isn't wanting you to give him any sort of yes. The attorney is wanting like something that he can really stand behind and hopefully win the case on. And what are we trying to do as CROs? We're trying to quote unquote win the case. We're trying to win whatever the goal is. We're trying to achieve the goal, which is getting that deletion or whatever the case is. And I mean, everything that I do with a notarized power of attorney for my clients. I even send it to the bureaus. I mean, it kind of helps. They'll send the correspondence, except for Experian, but the other two bureaus will send the response to me, which is kind of cool. But for the furnishers, there's really a lot of value in using a POA because you can call them, you can communicate directly with them. And if you know the facts, see, here's the interesting thing that I tell people about pre-litigation. I'm like, if you really understand the facts, you can probably, in the majority of the instances, put your attorney out of business. In other words, instead of referring the case to him to do the dirty work, just get on the phone and call the debt collector or whomever. Now, it's not going to work every time, but it's totally a numbers game. I mean, if you can, especially debt collectors, because they have the FDCPA, and if you can record a call with them and say, hey, we sent the 3 prior letters, and here's what they all said, and here's how you messed up every single which way. What are we going to do here? And that's what like 99% of the credit repair companies don't do, Doug, right? They're just firing out letters. They're not actually doing the dirty work, for lack of a better way of putting it. And if we can run our businesses, act as if, right? I think we would be surprised with the results that we can get. Act as if you are a lawyer. I mean, I'm not saying unlicensed practice of law, but learn the facts, build a fact-driven client file, and then you absolutely can talk to these people with a proper POA and the art of the deal, right? See what you can get deleted. If you still can't get from there, man, you've exhausted it, and you've got to hand these things off to a lawyer, as a last resort. But at least you've exhausted it. But so kind of back to where you are. I mean, as we're kind of taking this show in for a soft landing here, what kind of final thoughts do you have for our listeners and on the rebuttal to the rebuttals that you're seeing, and how we can kind of how what you do can be a benefit, and your mindset can be a benefit to our CROs that are watching.
Yeah, I think this show is helpful to all the people that are in the group, in that if they're thinking about doing the expert work, this may give them a little bit more comfort and a little bit more understanding of the types of things that go on as an expert. And hopefully, though, if they want to, they can reach out to me and we can talk about it further, because I think that sometimes people may not step into it because they're intimidated, or they don't really quite know what's going to transpire, or what has to be in a report, or what's the retainer I should charge, or any number of questions that they have. And so I guess in ending this, I would encourage all of your listeners and all the people in the group that if they do have questions about it, just email me or call me, one or the other, and we can talk about it, because I don't think that not knowing something should keep you from maybe doing something that could be really beneficial to yourself and your business, and help them make some extra money, and maybe give them a little more credibility with what they're doing. That's all.
Well, there's a lot of people out here in our space who are, I mean, we've got people in all 50 states, and they're looking for attorneys that they can build relationships with. And that's one of your strong points, is that you really do have relationships with lots of attorneys. I mean, and so what I'm trying to say is, for our audience out here, I mean, there's a lot of value in talking to Doug. Doug loves talking to people. If you're interested in, figuring out, hey, how can I become an expert? I mean, he's got an entire Rolodex of people. Maybe he can, connect you with an attorney in your neighborhood that you can go talk to, I mean, so Doug really is willing, to help and talk to people. So you said they can email you. Is that doug@dougminer.com? Is that where we can find you?
Yeah, doug@dougminer.com, easy email. And then, my phone number is at Easy Credit Relief. They can call me. But yeah, Stephen, I totally agree with you. I really enjoyed talking to people and helping them out. And just knowing I've been in their shoes and done credit repair. And look, if you feel that this is something that you're curious about, I don't want to be over encouraging, but I am. I would encourage anybody questions or they want to do it to get in touch with me.
Did you say your phone number is Easy Credit Relief?
No, I said it's on the Easy Credit Relief. You can find it on the Easy Credit Relief website.
Oh,
Or
okay. I was like, wait a minute, what the hell is Easy Credit? I was like, that's more than like 7 or 8 digits or whatever it is in a phone number. So, all right, yeah. So Doug at DougMiner.com, and you can also go to DougMiner.com. And of course, if you guys are interested in learning more about pre-litigation dispute strategies, you can check out my training course. We give a 30-day free trial, and it's $99 a month thereafter. You can go to creditrepairtrainingcourse.com, and we appreciate all of you guys watching. We bring this to you to bring you some unique information, really, it's really hard for you to find. I mean, honestly, to be able to talk to a guy like Doug. Doug, you are a rare catch, sir, and I appreciate you bringing this to our audience. And so that being said, guys, we will see all of you, or to bring back my Southern twang, all y'all on the next show. You guys take care.
see ya.